So good morning everyone. Good morning Chitralekha, good morning Mehul. I'm glad that you people wait for me even before I come live. Thank you so much. And good morning Soumya. Only 3 people have joined. And today we shall be discussing about a topic which has been discussed in the daily newspapers of today, giving it a caption of trifling freedoms or trifling values of individual freedoms, or treating values of individual freedoms as trifles. So a very good morning to all of you, Baat Jazbaat, Prableen, Mehul, Chitralekha, Soumya, very warm good morning, and all of the people who are now about to join the class, a very warm good morning to all of you. Today we have to discuss this case. Today we have to discuss this, topic of treating values of individual freedom as trifles. The hijab judgment has struck a blow against each of these principles: liberty, equality, and fraternity. So you must be knowing that we have certain concepts enshrined in the Preamble to the Constitution of India. And those preambles are considered as the bedrock of any democracy. The entire constitutional edifice of India is built up of, or is made up of, all these principles as are reflected in the Preamble to the Constitution of India. Now, what is Preamble? You must be knowing this. Now, let me introduce you this topic properly. What is the Preamble to the Constitution of India? American Constitution was the first constitution in the world to begin with the Preamble. Okay? American Constitution was the first constitution in the world to begin with the Preamble, because the Preamble highlighted the salient features of the Constitution. Okay? In order to know the nature of the Constitution, in order to know the source of the Constitution, in order to know the objectives of the Constitution, and also the date of adoption and date of enforcement of the Constitution, date of adoption or date of enforcement of the Constitution, it is not necessary that one person should go through the Constitution entirely and thoroughly. Okay, it is enough that if one has a bare perusal of the Preamble to such Constitution. Okay, a bare perusal of the Preamble to any Constitution gives us a comprehensive and a holistic idea about the source of the Constitution, the nature of the government it intends to establish, the objectives of the Constitution, the date of its adoption or the date of its enforcement. These are important nuggets of information which any person who is intrigued to read and learn about the Constitution should know. So Chitralekha says that it is a 4-word like text. Exactly. What was described by the Supreme Court in a presidential reference case of Berubari. In Berubari case, the Supreme Court said that it is the identity card of the Constitution. Baat Jazbaat says that Preamble is the introduction of the Constitution of India. Yes, Not only the Constitution of India, if we are talking about the preamble in general, it is like preamble to any constitution. Preamble is like the identity card of the Constitution. Preamble enumerates the basic ideas which the Constitution, is built upon. That is the preamble. And I have already told you that American Constitution was the first constitution in the world to begin with a preamble. That was the idea that was bought by almost all the democratic countries in the world subsequently, because having a preamble was enough for any common man to understand the nature of the Constitution, to understand the source of the Constitution, so that one can know that his or her country is sovereign. Okay. Now it is important. Now it is important that the hijab judgment has struck a blow against each of these principles: liberty, equality, and fraternity. Okay. Baat Jazbaatutum says that in Re Berubari ruled that preamble is not a part of Constitution of India and also not a source of any substantive law. That's true. That is absolutely right. Okay. In Re Berubari case, it was ruled that it is not a part of the Constitution of India, and because the question was regarding the amendability of the preamble, whether it can be amended or not. Okay, whether it can be amended or not. So the hijab judgment has struck a blow against each of these principles: liberty, equality, and fraternity. Okay. Now, Re Berubari case, in the same case, it was held that in Re Berubari case, it was held that the preamble is a part of the Constitution of the preamble is the identity card of the Constitution. Then again, there are certain principles which are enumerated in the preamble. Those are liberty, equality, and fraternity. Like we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. So in this paragraph, in the first paragraph, we come to know about the source of the Constitution. We come to know about the we come to know about the source of the Constitution, that the source of the Constitution lies with the people of India. Then we also come to know about the nature of democratic polity, what kind of a democratic government, what kind of a government this Constitution intends to establish, like its sovereign, socialist, secular, democratic republic. Then it talks about and to secure to its citizens justice, social, economic, and political, liberty of liberty of thought, expression, belief, faith, and worship, equality of opportunity, and to promote among them all, fraternity, assuring the dignity of the individual and unity, integrity of the nation. That's how it goes. These are the objectives. The first objective is justice, social, economic, and political, the concept of which was borrowed from the USSR, while the concept of liberty, equality, and fraternity was borrowed from the French Constitution, because the entire French Revolution was fought on the principles of liberty, equality, and fraternity. Okay, so the hijab judgment has struck a blow against each of these principles: liberty, equality, and fraternity. Okay, so that is the the writer, the author of this article is trying to assail the hijab judgment. Okay, that it is a question mark on the liberty, equality, and fraternity, because when we talk about hijab, it is a kind of liberty, it is a kind of freedom. Okay, when a woman or any individual is free to wear anything he or she likes, that's part of her liberty, that's a part of her freedom. Okay, and at the same point of time, if she is willing to wear burqa or a hijab, that is her right, that is a choice. When we can talk about the freedom of not wearing something, we can also talk about freedom to wear something. Okay, our social contract is built on an edifice that grants preeminence to individual choice. Now, this article is, the caption of this article is treating values of individual freedom as trifles. We are talking about that in certain cases, what we are seeing in the recent scenario, that state policies are given primacy over the individual freedoms, and individual freedoms are not given their due importance, are not given their due places. Okay, they are being treated as trifles. Okay, our social contract is built on an edifice that grants preeminence to individual choice. The Constitution's preamble recognizes this when it places an onus on the state to secure to all citizens, among other things, liberty, equality, and fraternity. The last of those values is fortified by a further commitment. The state, the preamble says, will guarantee fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So if you have any question up till here, you can please tell me. If you have any question or anything to add, you can please tell me. Any question up till here? Anything that you want to add? Okay, so our social contract is built on an edifice that grants preeminence to individual choices. Because we believe in a social contract. You must have come across this theory in political science. There's this social contract theory. The social contract theory explicitly tells us, it elucidates that there is a kind of contract between the state and the people, and the contract is in the social, this very social contract in a democracy. It talks about the individual choices, that the freedoms, the liberty of the individuals will be given primacy over the it will be given primacy over the state actions. The social contract, it contains this promise, it contains this pledge on the part of the state that it is in every situation going to protect the individual freedoms. The Constitution's preamble recognizes this. The Constitution's preamble, the preamble to the Constitution of India, recognizes those promises, and it places an onus on the state. The entire responsibility squarely falls on the shoulders of the state to secure to all citizens, among other things, what? Liberty, equality, and fraternity. We are talking about which liberty? Liberty of thought, expression, belief, faith, and worship. Okay, liberty of thought, expression, belief, faith, and worship. There is a liberty of thought. As a democratic citizen, I am free to have any kind of religious thought. Liberty of thought, expression, that is my freedom of expression. I am free. I'm completely free to express my religious ideas, and that is, a dress code is also a kind of an expression. Liberty of thought, expression, belief, that is my religious belief. I am free to have any kind of religious belief. Faith and worship, it is my freedom to worship my God the way I want to have the faith, to believe in some things, to have faith in the God, or not to even have faith in God. Then at the same time, equality of opportunity and to promote among them all. I have the equality. If because of some dress code, if somebody is not allowed to enter into the college premises, this is the violation of equality of opportunity. Okay, fraternity, assuring the dignity of the individual and unity and integrity of the nation. What about the dignity of the individual? What if someone finds a dignity in wearing a hijab? So fraternity means we are, we want to encourage brotherhood. So the last of those values is fortified by a further commitment. The last of those values, that means fraternity, is fortified, it is institutionalized only by a further commitment. The state, the preamble says, will guarantee fraternity, assuring the dignity of the individual and the unity and integrity of the nation. This is the one commitment on the part by the state, that the state has to commit it. The state has to promote this brotherhood. The state has to assure the dignity of the individual, that every person's dignity is equally important, and keeping that dignity up and above everything, we have to promote what? The brotherhood, the fraternity. Okay, the chief architect of the constitution, B.R. Ambedkar, saw the standards contained in these words as forming a triumvirate of values. B.R. Ambedkar said that saw the standards contained in these words as forming a triumvirate of values. Triumvirate of values means there is a triangle: liberty, equality, and fraternity, and you cannot separate any one of them with the rest of the two. So B.R. Ambedkar said he was the chief architect of the constitution, being the chairperson of the drafting committee. It was under his direct supervision that the constitution was drafted. It is such a big thing. So B.R. Ambedkar is said to be the chairperson of the drafting committee. There was so many committees in the Constituent Assembly, but drafting committee was the most important one, because it had to draft and arrange all those articles in sequence, and editing and all that, reading and rereading and proofreading and arranging the articles, understanding the principles. There were so many things involved. So B.R. Ambedkar is the chief architect of the constitution, saw the standards contained in these words as forming a triumvirate of values. Liberty, equality, and fraternity, he said, were principles of life, a union of Trinity. It's a union of Trinity. Divorce one from the other, and the very purpose of democracy will be defeated. Divorce one from the other, and the very purpose of democracy will be defeated, because we cannot separate liberty from equality and fraternity. We cannot separate equality from liberty and fraternity, and we cannot separate fraternity from liberty and equality. These are, interconnected. They are juxtaposed in each other. We cannot separate them. If liberty is existing in society, that means it has to be accompanied by fraternity and equality. And if we are talking about fraternity and we are working on this commitment to ensure fraternity, upholding the dignity of every individual, we will have to use liberty and equality as the instruments for doing that. At the same time, when we are talking about the equality, we will also have to give every individual the liberty to do anything he or she wants, unless it is directly in conflict with law. And also we will have to ensure the fraternity, assuring the dignity of the individual. So we cannot divorce one concept with the other two. And if that is done, the very purpose of democracy will be defeated. Even the existing notion will be completely a hoax then. So the Constituent Assembly believed that it was only a deep commitment to these principles that can help usher in a social revolution in the country. How can we usher in a social revolution? How can we unfold a social revolution in the country? We are talking about equality. If we are intending to build up an egalitarian social order, and how is that possible? It is possible only with these deep commitments to these principles that can help us usher in a social revolution in the country. The structures of India's democracy, the various minutiae of administration that the constitution spells out, were each built on the idea that securing individual happiness required the state to foreground these as standards. The structure of India's democracy, the various minutiae of administration that the constitution spells out, were each built on the idea that securing individual happiness required the state to foreground these as standards. Every minutest thing of regarding administration was spelled out clearly by the constitution, and every minutest thing depends upon these principles only. What is the idea? What is the bedrock? What is the grundnorm of the entire constitutional edifice? What is the grundnorm? The grundnorm is that securing individual happiness. Securing individual happiness. We have to secure individual happiness at any cost. We cannot compromise with it. And individual happiness is the most when he is given complete freedom. Obviously, we are not talking about giving absolute freedoms. That is not wise to give absolute freedoms. Just like power corrupts and absolute power corrupts absolutely. So freedom, absolute freedom is also going to ruin the society. That is not possible. Not even in a democracy, there are some reasonable restrictions which are necessary in the interest of the society and in the interest of law. Obviously, no freedom can be sustained if it is in direct conflict with law. But we are talking about maximum liberty and maximum freedoms. If it is not in direct conflict with law, it has to be, it has to be allowed. It has to be sustained. That securing individual happiness required the state to foreground these standards. Okay, then several hijab-clad Muslim students missed classes exam in Karnataka. Now, what is happening? We are enforcing popular morality. What is the popular morality? That what the majority is saying is morality. We are just accepting it. This is not democracy. This is majoritarianism. And majoritarianism is in direct conflict with democracy. Majoritarianism is not the principle of democracy. Do remember this. Majoritarianism is not the principle of democracy. They cannot exist together. They cannot exist together. Majoritarianism is something that we are following the principle. It is a principle of mobocracy. It is not a principle of democracy. There is a mob. There are majorities which are against a set of standards of a section of population. And when how does this majoritarianism or mobocracy works? It enforces popular morality. Now, what is popular among the majority of the population becomes moral. What about the individual freedoms and the moral standards of the other section of the population? Don't you think that it is also they also deserve to be treated equally in the society? And there are moral standards of of this section of population also, which is not represented in this mob, which is not represented in this majority. This is the thing. We cannot enforce popular morality. The notions and the standards and the parameters of morality, they are designated. They are given to they are given to the society according to according to the constitutional principles, and not what the majority says. The majority can form a government, democratic government, by voting in elections, but this majority cannot enforce those popular moral standards. In that picture, independent courts, the framers thought, would stand as a guardrail against any effort to undermine social democracy. But far from acting as sentinels on the queue-vive. What do you mean by sentinels on the queue-vive? What do you mean by the sentinels on the queue-vive? And any idea? Any idea about the sentinels on the queue-vive? What do you mean by the sentinels on the queue-vive? And any idea? सेंटिनल मीन्स अ गार्ड, चौकीदार जिसको कहते हैं, बॉडी गार्ड जो आपका रखवाला होता है, अंगरक्षक, ठीक है, जो आपकी हिफाजत करें. Q5 मीन्स ऑन एन अलर्ट, ठीक है, अलर्ट रहे. अलर्ट रहे, एकदम चौकीदार जो है वो एकदम क्यू वाइव अलर्ट रहे, सेंटिनल ऑन द क्यू वाइव, बट फार फ्रॉम एक्टिंग एज सेंटिनल्स ऑन द क्यू वाइव। अंडरस्टूड? किसके बारे में बात हो रही है? सुप्रीम कोर्ट ऑफ इंडिया के बारे में बात हो रही है। सुप्रीम कोर्ट क्या है? सेंटिनल ऑन द क्यू वाइव, सेंटिनल ऑन द क्यू वाइव ही है, ठीक है। But far from acting as sentinels on the QYV, as a former Chief Justice of India once described the Supreme Court of India's role, the judiciary has time and again enforced the popular morality of the day, treating values of individual freedoms as dispensable trifles. Okay? Understood or not? You know, the author is trying to say that once our Chief Justice of India described the Supreme Court's role as sentinel on the QY, that means a bodyguard, a guard, okay, a guard, a watchman who is on an alert, you know, who is on a lookout, who is on an alert, like as soon as there is an apprehension of danger, he is ready to hit the hit the enemy, hit the attacker. That is like sentinel on the queue vibe. So once a Chief Justice of India, he described Supreme Court's role as a sentinel on the queue vibe. But today, far from acting as sentinels on the queue vive, you know, the judiciary has time and again enforced popular morality of the day. Judiciary has just given legal attestation or affirmation only to what the majority was emphasizing or what the majority was saying. It did not make an endeavor to delve deep into those constitutional principles and find out how far it is important to give this individual freedoms, how far it is important to ensure these individuals' freedoms over the majority views or the majoritarianism or what a particular mob says. So the judiciary has now time and again, what the judiciary has started doing, the judiciary has time and again enforced the popular morality of the day, treating values of individual freedoms as dispensable trifles. Dispensable trifles means that judiciary is trying to treat these individual freedoms as trifles, as nothing, that they're just petty trivial things of insignificant worth. That's what the judiciary is trying to say. And the judgment by the Karnataka High Court in Resham versus the state of Karnataka, that's what already we have gone through, is the newest addition to this litany. The litany is not very old. The litany, as you know, has just started. And what is the recent addition to this litany? It's the case of Karnataka High Court's judgment in Resham versus the state of Karnataka, where the majority view or the popular morality was enforced by the judiciary. It did not talk about the liberty of the people, liberty of the girls who wanted to wear hijab. It did not talk about the doctrine of proportionality. It did not talk about how far it is important to give primacy to the individual freedoms. Isn't it? It upholds a ban imposed on the use of hijabs by students in classrooms across the state, and in doing so strikes a blow against each of these principles contained in B.R. Ambedkar's Union of Trinity. So if you have anything to add, any question, you are most welcome to do that. Please do it. Any question? If you have any question, please go ahead. Only Mehul is commenting today. What about others? Okay, baat just baat, no questions. Courts must not look at popular view, Prablin says. The Supreme Court in Chiranjit Lal Singh had held that even one person forms a class and his rights should be protected accordingly. Exactly. When the Supreme Court in 1958 propounded the theory of doctrine of reasonable classification based on intelligible differentia under Article 14 of the Constitution of India, the Supreme Court said that, even one person can form a different class, and there can be a reasonable classification based on different intelligible differentia even for one person. And here there are so many people. Okay, so exactly, Prablim, you are very absolutely right. It was the court is just trying to enforce the popular morality and nothing else. Now what the precedent is being used by the court? The judgment is premised on three broad conclusions. What are those broad conclusions? First, the court holds the wearing of hijab is not essential to the practice of Islam. We have already discussed this, that doctrine of essential religious practice is not something which is to be applied in a case like this. When the group rights of one section of population are in direct conflict with the group rights of another section of population, then it becomes important for the judiciary to decipher which religious practice is essential religious practice of that religion. Okay, we cannot, only the essential religious practice will then be sustained and the other religious practice will have to go. Okay. But when the group rights or the individual freedoms are in direct conflicts with the state action, we cannot apply the doctrine of essential religious practice, because the state action cannot be given primacy over what? Over the individual freedoms. And also one thing, even if the state action or the executive policy or any law is very important, it must have a clear object, and the object must have a direct nexus with the restriction imposed. Second thing, the doctrine of proportionality is very important. Only the restriction should be used only up to an extent which is important, which is necessary. Otherwise, it's not going to work. Okay. So the court holds that the wearing of a hijab is not essential to the practice of Islam, and therefore the petitioner's right to freedom of religion, if that restriction goes beyond what is required, it becomes unconstitutional. Okay, so the judgment is premised on three broad conclusions. First, the court holds that the wearing of hijab is not essential to the practice of Islam, and therefore the petitioner's right to freedom of religion is not impinged. Second, it finds that there is no substantive right to free expression and privacy that can be claimed within the confines of a classroom. That means the court held that classrooms are qualified public places where one cannot claim his freedom of expression and privacy. Every individual freedom is subject to the rules and regulations of that institution. That is absolutely right. But what about the constitutional rights? What about the fundamental rights? If you are holding classrooms as qualified public places and making them immune from the fundamental rights, this means that you are giving primacy to the rules and regulations and the state policies. I understand that there is a uniform dress code in every institution which needs to be followed, and it has to be respected. It has a great dignity and it has a purpose. There is no doubt about it. But the question again comes in the same way, that at least the hijab or the headscarf of the same color as the uniform should have been allowed. It does not in any way violate the uniform code. And third, according to it, since the government's order does not by itself ban the use of a hijab, and since it is otherwise neutral, there is no discrimination aimed at Muslim women students. The Karnataka judgment did not even once mention the word Muslim. It talked about the students in general. So by doing that, or by not doing that, this Karnataka High Court has escaped from being implicated in a kind of a situation where it could have been labeled as doing something against the Muslim community. That was completely set aside by not using the word Muslim and talking about the students in general. Okay, so that's how the judgment is premised on three conclusions. Understood? These conclusions suffer from one flaw or another. The writer says that these conclusions, they suffer from one flaw or another. In rejecting the plea that the wearing of a hijab is a legitimate exercise of religious freedom, the court refers to a plethora of precedent that points to only essential religious practices enjoying constitutional protections. When we talk about freedom of religion under Article 25 of the Constitution, we say that only those freedoms are allowed which are essential religious practices and not others, not other practices. Now the question is very sensitive. If you are only allowing essential religious practices, then the question is that why are you not allowing other religious practices? Because that is a question mark on the secular nature of the Constitution and the democratic polity. Why are you not allowing other religious practices? Okay. The court refers to a plethora of precedent that points to only essential religious practices enjoying constitutional protection. According to the court, the petitioners failed to produce any evidence to show that the use of a hijab was essential to Islam. Yet, despite this, it proceeds to perform a theological study, which one would think it is ill-equipped to do, especially without conducting a full-fledged trial, and concludes that Islam does not make the wearing of a hijab mandatory. Okay, and concludes that Islam does not make the wearing of a hijab mandatory. Yet, despite this, it proceeds to perform a theological study, which one would think it is ill-equipped to do, especially without conducting a full-fledged trial, and concludes that Islam does not make the wearing of a hijab mandatory. Okay. This is an extraordinary finding for a secular court to make. This is an extraordinary finding for a secular court to make. No doubt similar leaps of judgment have been made by the judiciary in the past. For example, in 2004, the Supreme Court concluded that the performance of the Tandav dance was not indispensable to the Anand Marge's faith. This is important. Please take note of this paragraph. In 2004, the Supreme Court concluded that the performance of the Tandav dance was not indispensable to the Anand Marge's faith, even though the followers of that religion believed it to be so. The question is not solely about hijab. The question is on, completely on the authenticity and the feasibility of the doctrine of essential religious practice. If this doctrine of essential religious practice is continued to be followed in this country, a time will come that religion will become a rare commodity in this country. Because slowly and gradually, almost every religious practice will then stand diluted and completely annihilated from the social discourse of India. Tandav dance is one of the most essential and indispensable religious practice in the Ananda Marji's faith. But despite their strong belief, it was held to be not an essential religious practice. Essential religious practice is an infamous doctrine which has to go, because this is unnecessarily diluting the religion. Every time a question is raised in some or the other religious activity, the question goes to the court. The court simply applies doctrine of essential religious practice and says that, and comes with a, conclusion that this is not an essential religious practice. This is not an essential religious practice, even though the followers of that religion believed it to be so. This is a dangerous precedent. Are you getting my point? So this ERP doctrine, and judges are no one to decide about the religious practice, which religious practice is essential and which is not. And for that, you cannot simply read the religious text. You will also have to peruse the entire history of that religion. How far and how significantly that practice was, that religious practice was observed in the earlier times. And if a significant worth was attributed to it in the previous days, then it should continue to be given. We cannot simply dwell upon some religious text, and that too when we are not the competent people to understand the interpretations of such religious text, to understand what and how and why not a particular practice is not an essential religious practice, isn't it? But if the Karnataka High Court's inference is partly based on flawed doctrine, it must take the blame for posing to itself the question of whether at all a hijab was essential to religion, isn't it? Now, there is a direct conflict between a free choice and a state action. There is a direct conflict between a free choice and a state action. Unlike many of the cases in which the doctrine of essential practice is invoked. Baat Jazbat is asking what is the name of the Anand Marge's case. I don't remember, Baat Jazbat. I'll have to see. Okay, I don't remember. You can Google this and find the name. Free choice and state action. Unlike many of the cases in which the doctrine of essential practice is invoked, this was not a case where individual freedom was at odds with the group rights. That's what I've already told you. It's a situation where free choice or the individual freedoms, they are in direct conflict with the state action. There are not two groups. It's not rights versus rights. It's rights versus the state action. When are you going to invoke the ERP doctrine? The ERP doctrine is invoked when there is a conflict of rights with the rights. When it is rights versus rights. Rights of one group versus the rights of another group. And if such a question is put before the court, the job of the court is to decipher the ERP of each religion. And the one religious practice which is found to be not an essential religious practice has to go. Because the other one, being the essential religious practice, has to be sustained. Okay. So it can be invoked when there is a situation of rights versus rights. It cannot be invoked in a situation when it is rights versus a state action. On the contrary, this was a case where exercise of free choice was curtailed by state action. The petitioners had contended that they wore the hijab as a matter of conscience. Article 25 of the Constitution guarantees to all persons not only an equal right to profess, practice and propagate religion, but also a freedom of conscience. Freedom of conscience means that you have a liberty, you have the freedom to establish your relation with God the way you want to believe and to perceive God the way you want to. No one else, not even the state, is going to tell you how you should perceive God, what is the imagination of God in your mind, and how it should be like, and what to think about and what not to think about. No one is going to tell you. That is completely your prerogative. Counsel pointed to the Supreme Court's judgment in Bijoy Emmanuel versus the state of Kerala 1986, a very popular case. We have discussed it so many times. There were 3 children belonging to one particular religious tribe in the state of Kerala, and who refused to sing the national anthem. And that's how the Jehovah's tribe did not allow them to sing any other song apart from their own religious songs. And when the matter went before the Supreme Court says that it is right to keep silence and it is their religious freedom that has to be given primacy over the law. And we cannot say that if they are standing straight while keeping their mouths completely shut, that does not amount to disrespect or insult in any manner. There the court ruled that so long as the students conscientiously believe that they must not participate in the recital, their rights could be abridged only in the interest of public order, morality or health. Okay? And that's how the Article 25 begins. Subject to public order, morality or health. Now, if your religious practice or any of your religious freedom is hampering or threatening public order, disturbing public order, or it is against the basic standards or general standards of morality, or it is violating the health of the people in general, you are doing something which is creating nuisance in the society, then definitely your religious freedom can be suppressed and curbed, and it should be curbed. Then public order is important, moral standards of the society, they are important, and health standards of the society are important. But these should be genuinely interpreted, and the context should be the context attributed to them should be the one as as given to them by the Constitution. Simply you cannot enforce the popular majority view. Okay. In Resham, the Karnataka High Court draws a facile distinction from Bijoy Emanuel. The judgment holds that there is no evidence in this case that the petitioners conscientiously believed in the necessity of the hijab. This is an anomalous given that once a pleading is made on affidavit, the onus ought to have been on the state to establish that the petitioners were not in fact wearing the hijab out of a sense of conscience. Okay, are you getting my point? So this is anomalous given that once a pleading is made on affidavit, the onus ought to have been on the state to establish that the petitioners were not in fact wearing the hijab out of a sense of conscience. Then the court then proceeds to make an even more astonishing assertion. What is the most astonishing assertion? What comes as a surprise for many of us is that all cases where a right of conscience is pleaded, according to it, are ipso facto cases of religious freedom and therefore ought to be subject to the test of essentiality. Okay. This conclusion ignores the fact that Bijoy Emanuel was explicitly decided based on conscience and that conscience need have no direct relation to religious faith. The Karnataka High Court said, where the right of conscience is pleaded in a petition, that is completely a case of religious freedom. And that right of conscience should be subject to essentiality. That means whatever your conscience is regarding your religion also needs to be subject to the test of essentiality. This conclusion ignores the fact that Bijoy Emanuel was explicitly decided based on conscience and that conscience need have no direct relation to religious faith. It is possible, for example, that the hijab might not be essential to Islam, and yet that Muslim women choose to wear it as an exercise of their own individual beliefs. It is about their conscience, but their conscience was made subject to the test of essentiality. On the classroom space, now that the court was simply unprepared to grapple with this difference is even more evident in its rejection of claims based on free expression. The petitioners argued that in choosing to wear the hijab, they were merely exercising a form of identity relatable to their rights to freedom of speech and privacy. The court counters this by holding that classrooms are qualified public places where individual rights cannot be asserted to the detriment of general discipline and decorum. That's what I have already discussed, that it is treating classrooms as a qualified public place where you cannot claim your rights. And every individual's freedom is subject to the detriment of general discipline and decorum. In spaces such as these, and the court draws a remarkable analogy with prisons, substantive rights, the judgment holds, metamorphose into derivative rights. It is unclear what the ruling means by all this, except that these apparently derivative rights are incapable of being invoked in protected environments. You cannot invoke them in protected environments. And you never know what is the other public place which is soon going to become a qualified public place. In all of this, the court ignores the classic test for determining when and how the right to free expression can be legitimately limited. Okay, that is the test of proportionality. In all of this, the court ignores the classic test for determining when and how the right to free expression can be legitimately limited. That is the test of proportionality. That's what I have told you. Whenever there is a state action, whenever there is a law on the part of the state, and whenever it intends to violate the fundamental right, it has to be seen, it has to be tested that there is a need of the law. The law should have an object. The object should have a direct nexus with the restrictions imposed. Okay, and the restriction imposed should be only in the proportion, only what is required, not beyond what is required, not beyond what is necessary. And if it goes beyond what is necessary, then definitely it is going to be a sheer violation of the doctrine of proportionality. There is, according to the judgment, no need to dwell on legal doctrine, because the petitions we are treating do not involve the right to freedom of speech and expression or right to privacy to such an extent as to warrant the employment of these tests for evaluation of argued restrictions in the form of a school dress code. In this manner, the court also brushes aside requests for reasonable accommodation. In this manner, the court also brushes aside requests for reasonable accommodation, isn't it? Now, many accommodations, Kendriya Vidyalayas, for example, as the petitioners claimed, allow for hijabs within the contours of the prescribed uniforms. But the judgment holds that to make such an accommodation would defeat the very purpose of uniforms. This finding fails to recognize that even within the existing dress code, many accommodations are in fact made. For instance, religious and cultural marks on the forehead and accessories on other parts of the body are not disallowed. If the purpose of the uniform is to allow for no differences, surely every exhibition of faith in the classroom must be stamped out. Therefore, we can only see the failure to provide for a reasonable accommodation for the hijab as deliberate discrimination wrought on Muslim women. The judgment makes repeated references to constitutional secularism. But secularism, properly understood, demands precisely what the petitioners here were pleading for: the right to agency, choice and equal treatment, and more than anything else, a guarantee of fraternity undergirded, as the preamble says, with dignity to every individual. So this is all about treating individual freedoms as trifles. If you have any question, anything to say, anything to add, you are most welcome to do that. Okay, no questions. Baat Jazbaat. Anyone else? Any question? Any questions? No questions. Okay, then I'm signing off, and let's meet the next week with with some judgments. Okay. Till then, all the very best. Enjoy your weekend, and Eid Mubarak in advance to all of you. Thank you, Ananya. Khair Mubarak, Baad Jazbaan.